It's my pleasure to introduce Professor Vladeck, who will be speaking on the ethics of emergent types of war, the Patriot Act, black sites, and enhanced interrogation techniques. Professor Vladeck is a professor of law at American University, Washington College of Law. His teaching and research focus on federal jurisdiction, constitutional law, and national security law. A nationally recognized expert on the role of the federal courts in the war on terrorism, Vladeck's prolific and widely cited scholarship has appeared in an array of legal publications, including the Harvard Law Review and the Yale Law Journal. And his popular writing has been published in forums ranging from the New York Times to BuzzFeed. Vladeck, who is co-editor of Aspen Publishers' leading national security law and counterterrorism law casebooks, frequently represents parties or amici in litigation challenging government counterterrorism policies, and has authored reports on related topics for a wide range of organizations, including the First Amendment Center, the Constitution Project, and the ABA Standing Committee on Law and National Security. He also serves on the Executive Committee of the Board of Directors of the ACLU of the nation's capital. Professor Vladeck has won numerous awards for his teaching, scholarship, and service to the law school. He's an elected member of the American Law Institute, a senior editor of the peer-reviewed Journal of National Security Law and Policy, co-editor-in-chief of the Just Security blog, a senior contributor to the Lawfare blog, the Supreme Court Fellow at the Constitution Project, and finally, a fellow at the Center on National Security at Fordham University School of Law. So, it is a great pleasure to introduce Professor Vladeck.
Thanks, Paul. Wow. Okay. I guess that's me. So I said to any number of people last night that I was just really, really happy that I wasn't going last. That worked out really well for me. So I'm last, which means I am standing in the way of lunch, your travel home, and who knows what other fun pursuits. So let me apologize in advance for what follows. If nothing else, let me encourage you to use my talk today to fill out your evaluation forms of everybody else. I think that would be an excellent use of your time. Thank you to Paul for that lovely introduction, to Alan, to JD, to everyone at both FPRI and the First Division Museum. It's been a real treat to spend the weekend here and with all of you. I want to devote my time this morning, or increasingly this afternoon, to posing a fundamental question about the evolution and current state of U.S. counterterrorism policy. And here's the question. Should the United States response to the threat posed by transnational terrorism be grounded in civilian law enforcement, military force, or some combination of the two? And just to spoil the punchline, I don't intend to answer this question. I'm a law professor, after all. We don't answer questions. Instead, my goal is twofold, to document how the U.S. response has evolved since the September 11th attacks, and to highlight what lessons, in my view at least, we should and hopefully could have learned along the way. So that's my plan. There are going to be a lot of details, so there will be a quiz at the end. I was going to walk in and tell you there was a pop quiz on the reading, but I thought that would be rude. All right, so let's start at September 11th. So our story begins with the 9/11 attacks and with the inadequacy of civilian law enforcement. It became clear pretty quickly after the attacks that the direct perpetrators had all died. Within about a week, it became clear that the responsible groups were based in Afghanistan, a country which at the time we did not have diplomatic relations with, and which in any event was controlled by the Taliban, who were not exactly hurrying to help us in our investigation of the attacks. It also became clear that we were terribly at risk for future attacks, and that prevention and intelligence gathering as part of that prevention were going to move to the front of the agenda as opposed to the normal reactive mode of law enforcement. And finally, and I think this point is never given enough attention, it also became clear that most of the criminal terrorism laws that might otherwise have been used to prosecute individuals who were captured and or arrested after 9/11 did not apply extraterritorially. I can't even say that word. Extraterritorially, which is to say, right, that we could not prosecute people based on purely foreign conduct. It was not actually illegal on or immediately after 9/11 to, among other things, provide material support to designated terrorist organizations if at all relevant times the individual in question, including U.S. citizens, were outside the United States. Right? So there were all kinds of reasons why immediately after 9/11, anyone, whatever their politics, whatever their philosophy, would have looked at this problem and said, civilian law enforcement is not going to be enough. Instead, what happens is a subtle but definitive move toward a very bright line, where on one side we would apply military force, on another side we would apply civilian law enforcement, and that bright line was the U.S. border. Right, that at least in the weeks, months, and even years after 9/11, we drew a very bright line based on territory. For transnational terrorism suspects located outside the territorial United States, military force was going to be and did become the preferred paradigm. For individuals located within the territorial United States, civilian law enforcement, arrest, interrogation by police, trial in civilian court would be the preferred paradigm. And this move is manifested in three major developments. So the first comes 1 week after 9/11. On September 18th, Congress enacts a statute called the AUMF, the Authorization for the Use of Military Force. In 60 words, it basically provides the legal framework for all military force since in the context of counterterrorism. Bear with me, I'm going to read those 60 words to you. Quote, that the President is authorized to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks on 9/11, or harbored such organizations or persons, in order to prevent any future acts of international terrorism against the U.S. by such nations, organizations, or persons. Note a couple of things. We didn't identify who it was. Right, because on September 18th, we actually still didn't know. No geographic constraints. The president gets to decide who the enemy is, but everything is tied to those who were responsible for 9/11. Okay, it was not a general authorization of force against terrorists. It was a specific authorization against the groups who the president ultimately would say were responsible for 9/11. 3 days later, President Bush goes on national television, and in addition to mispronouncing nuclear, identifies al-Qaeda and the Taliban as the two groups that were responsible for 9/11. Now, what's really important to understand is that AUMF is still on the books today, nearly 14 years later, and it has not been amended. So this vague, open-ended statute that doesn't identify who the enemy is or where the war is or anything like that, it's still there today. Indeed, the Obama administration has even taken the position, as Defense Department General Counsel Steve Preston, Jay was his predecessor, told the American Society of International Law last week, the speech that Charlie referred to, that ISIL, right, the Islamic State, is covered by the 9/11 AUMF. This is especially remarkable when you consider that the Islamic State did not exist in 2001 and therefore could not have had any involvement in the 9/11 attacks. All right, so that's the first piece of this framework, the AUMF. The second piece comes about a month later. On October 26, 2001, Congress enacts the USA Patriot Act. Do we know that that's an acronym? Does anyone know what the acronym actually stands for? All right, I'll cheat. Uniting and strengthening America by providing the appropriate tools required to intercept and obstruct terrorism. Some congressional staffer got a really, really nice bonus for coming up with that one. So whereas the AUMF was directed outwards at military threats overseas, the Patriot Act was directed inwards and included a range of new law enforcement and surveillance authorities, some of which were controversial at the time, some of which have become controversial lately thanks to everyone's best friend, Edward Snowden, some of which weren't controversial at all, were just modernizing updates to those authorities. The Patriot Act also provided short-term authority for administrative detention without trial of non-citizen terrorism suspects for up to 7 days. It's never been used, but it's still on the books today. And the Patriot Act took a very modest step toward expanding the territorial scope of some of our criminal terrorism laws. So Congress began to realize that we should be applying these laws overseas and started to tweak a couple of them. So that's two. The third big step comes 2 weeks later. On November 13, 2001, President Bush issues what he calls a military order regarding the detention, treatment, and trial of non-citizens captured in the fight against terrorism. It is this military order that leads to the establishment of detention facilities at Guantanamo, at Bagram, military commissions at Guantanamo, and also, we come to learn, secret detention facilities elsewhere. The military order only applies to non-citizens, and although it's not expressly focused overseas, it is widely understood as pointing that way. So we see on the one hand the AUMF and the military order, which are looking overseas, and on the other hand the Patriot Act, which is looking domestically, all going toward this bright line distinction. Where you are determines which paradigm we're going to use in the war on terrorism. In practice, this distinction was borne out. So beginning in late October 2001, the U.S. starts conducting offensive military operations on the ground in Afghanistan and along the Afghanistan-Pakistan border. These operations, unsurprisingly, produce detainees. Where there are sustained ground combat operations, hopefully you're going to win and capture people. Some of these detainees are handed over to the CIA, where they are interrogated and tortured at a series of so-called black sites. We now know, thanks to the Senate Intelligence Committee's torture report, that there were as many as 119 men in the CIA's so-called RDI program, Rendition, Detention, and Interrogation. And while I realize it's a bit fraught to group the CIA in with military force, it was largely understood in that context that the CIA was, in effect, supporting the military paradigm by conducting intelligence. Others are sent to third-party countries where many were allegedly tortured at the behest of the U.S. government. This policy was given the awfully euphemistic name, extraordinary rendition. But an overwhelming majority of the men we captured and held on to and didn't just release right away, were transferred to U.S. military detention facilities at Bagram and Guantanamo, which received its first detainees in January 2002. At their high watermarks, there were well over 1,000 detainees in U.S. custody at Bagram and 779 men at Guantanamo. Just to sort of skip ahead, we're down to 122 today. So that's the fall off. At about the same time, if we come back to the home front, the FBI begins a massive program of domestic arrests of non-citizens, primarily, although not exclusively, of Arab descent for petty offenses and or technical immigration violations, taking advantage of some non-obvious interpretations of old authorities, along with many of the new surveillance and arrest powers granted by the USA Patriot Act, and similarly, a small number of high-profile criminal prosecutions are brought in U.S. civilian courts, including the case against the alleged 20th hijacker, Zacarias Moussaoui, who was arrested, I think, in Florida. Minnesota. He was in Florida, then went to Minnesota. And with vanishingly few exceptions, this bright line distinction, military force and detention overseas, civilian law enforcement at home, was observed consistently and came to dominate U.S. counterterrorism policy from that point, from early 2002 through June 2004. All right, so that's like the first period in our story. Book 1 in Game of Thrones. So at the end, Sean Bean loses his head. Okay. Did I just spoil season 1 of Game of Thrones? Okay. So now we segue to part 2. So part 2 begins in around June 2004 and goes through the end of 2006. And it's in this sort of middle period where this paradigm, the bright line, military force overseas, law enforcement at home, starts to worry some people. And cracks begin to emerge. And I want to suggest there were actually 6 different events between spring 2004, fall 2006, that all sort of just pushed the snowball down the mountain even further, right, that added to the consensus to move away from this paradigm. So the first and we obviously talked about this a bit yesterday, was the disclosure of the torture photographs from Abu Ghraib, a different prison in a different war, but a very public vindication of charges that had been brought by a wide array of civil liberties and human rights groups that the U.S. government was engaged in abusive interrogation techniques. After all, if it happened at Abu Ghraib, why didn't it stand to reason that it was also happening at Guantanamo and elsewhere? And that's in April of 2004. Indeed, that happens the very night of oral argument in the Supreme Court in one of the first terrorism cases. And at that argument, Justice Ginsburg had specifically asked the government lawyer, then Deputy Solicitor General Paul Clement, does the U.S. torture? And Paul Clement says, no, absolutely not. We would never, ever do that. That night, it's like someone planned it. The pictures show up on 60 Minutes. Right? So that's the first chink in the armor. The second event comes 2 months later with the Supreme Court's June 2004 decision in a case called Rasul, R-A-S-U-L, versus Bush. This was the first of 4 decisions the court has handed down, specifically about Guantanamo. Now, the actual question before the court in Rasul was very narrow. As a matter of statutory jurisdiction, could the federal courts hear habeas petitions from non-citizens held at Guantanamo? But in answering that question in the affirmative, the justices sent a very clear message that the federal courts would, and indeed should, review not just the merits of the Guantanamo detentions, but also perhaps the conditions at Guantanamo. Just 10 days later, the government took the first steps to provide more process to the Guantanamo detainees, to allow international observers to visit the base, to improve the conditions of confinement at Guantanamo, to provide lawyers to the Guantanamo detainees, and so on. All right, the third event, if we're keeping score, was Congress's enactment of the Intelligence Reform and Terrorism Prevention Act of 2004. I lovingly call it IRPA. Because why not? Which, among other things, expanded the single most important and broadest criminal counterterrorism law. So this is a statute that's codified at 18 U.S.C. 2339B. You don't care about that. But this is a statute that makes it a crime to knowingly provide, quote, material support, unquote, to a designated foreign terrorist organization. Well, material support means anything. It means money. It means expert advice or assistance. It means supplies. It means support, counseling, whatever you name. It means yourself. Providing yourself to the organization violates the statute. And it's this statute that has been used in an overwhelming majority of the post-9/11 terrorism prosecutions. It's this statute that in 2004 Congress applies overseas. So as a result, it was now a violation of U.S. law for anyone, anywhere in the world, to provide any kind of support to a designated foreign terrorist organization, regardless of their intent. This is not an intent crime. All that you had to show, if you're the government, is that the person who provided the support knew or should have known that the group was a designated terrorist organization. The courts have held that means all they had to do was read the Federal Register or be in a position to read the Federal Register. How many of you guys have read the Federal Register? Exactly. But the court assumes that you all have, so congratulations. Okay. The fourth event came over a little over a year later when the Washington Post disclosed details on the CIA's detention program and the so-called black sites, these secret prisons in foreign countries, in late 2005. This disclosure helped to precipitate the Detainee Treatment Act of 2005, which included something called the McCain Amendment, a measure that was at least meant to prohibit the abuse of detainees in U.S. custody. It ended up being worded in a way that made it toothless. But at least it was a symbolic gesture, I guess. The fifth and most important event, the real turning point in this whole story, came the following summer in June 2006, when the Supreme Court decided Hamdan v. Rumsfeld, the second of its 4 Guantanamo decisions. Now, Hamdan was actually about the legality of the military commissions President Bush had created to try some of the Guantanamo detainees for war crimes, and in Hamdan, the court ends up saying President Bush lacked the authority to do so. He needed Congress to pass a new statute. But along the way, The Supreme Court expressly held that common Article 3 of the Geneva Conventions, which requires humane treatment of all detainees, whether or not they're POWs, right? Whatever their status, it requires humane treatment. The court says that applies to the non-international armed conflict between the United States and al-Qaeda and the Taliban. So whatever else may be true about the status of the detainees, about the applicability of the Geneva Conventions, Hamdan says this one critical humane treatment provision does and must apply. That's a pretty big deal. I would dare say in the 11 terrorism-related cases the Supreme Court has taken since 2001, this is one of its most significant single rulings. Hamdan therefore made it quite clear that the use of enhanced interrogation techniques by the CIA and the military was almost certainly unlawful, notwithstanding controversial memoranda concluding to the contrary that had been issued by the Justice Department's Office of Legal Counsel in 2002 and 2003. It therefore takes off the table, I think, the question of whether these are effective methods, because either way the court says they're not permitted. The Hamdan court also rejected the argument that had been in vogue in the Bush administration that various statutes purporting to limit the government's ability to detain and interrogate terrorism suspects were unconstitutional in violation of the president's Article 2 powers. Hamdan says, you have got to be kidding. Sixth, and finally, this is the last sort of moment in the story, in direct response to Hamdan, President Bush transfers virtually all of the remaining high-value detainees who were then being held at CIA black sites to Guantanamo. And Congress, at President Bush's urging, passes the Military Commissions Act of 2006, which provides the statutory authority for military war crimes trials that the Hamdan court had held was lacking. So I know this is a lot of information, but taken together, these developments drove home the limits of the military force paradigm because they at once, one, dramatically reduced the perceived value of holding new detainees in military detention, and two, dramatically increased the government's ability to incapacitate terrorism suspects, even those located overseas, through the criminal justice system, without regard to where they were captured or what specific acts of terrorism they may or may not have been plotting. Right? The real value of the material support statute is that you can prosecute people for very early steps in a terrorism operation. You don't actually have to show that they were about to blow up anything. That's why long before the 2008 presidential campaign, U.S. policy had already witnessed a fundamental shift away from military force as a first resort and toward more of a qualified preference for civilian law enforcement for new cases. The harder question was what to do with the hundreds of men already at Guantanamo. Most of them could not be tried in U.S. civilian courts, either because, one, the evidence against them was obtained through torture and was therefore inadmissible. Two, their conduct wasn't actually unlawful at the time it was committed because it was overseas and the relevant statutes didn't apply. Or three, some combination of both. And we don't really know how many fall into each of these. But the number of new cases of military detention dropped off a cliff. Indeed, we can count on one hand the number of new detainees who were sent to Guantanamo in 2007 and 2008, and none, zero, have been sent there since. Right? So it's been 7 years since we actually sent any new detainees to Guantanamo. All right, so that's sort of part two, right? The move away from the first couple of years in the pro-military force paradigm. Part three, sort of the last part, is sort of from that point onwards, right? President Obama comes along, and of course, all is well, right? He ends climate change, he solves pollution, he, invents the internet. Oh wait, that was Al Gore, sorry. So President Obama comes along. At the time he's sworn in January 2009, he was facing three very different questions. First, what to do about Guantanamo. All right, so on the day he comes to office, there are 242 detainees still at Guantanamo. Second, what to do about new terrorism suspects arrested either by us or by somebody else overseas. Third, what to do about terrorism suspects overseas who cannot be arrested because they're in a part of the world without functioning civil authority. For example, a large swath of Yemen, parts of Somalia, the tribal areas along the Afghanistan-Pakistan border, parts of Libya, parts of Iraq. This list sadly gets longer every time I write it down. So let me take these in order. So with regard to the 242 detainees who were then at Guantanamo, the first thing President Obama does, he signs an executive order saying, I am going to close Guantanamo. How'd that work? Not so well. You guys are a tough audience. I must be last. All right. You guys are like, I don't know. How did it work? So to be sure, litigation has helped. So of the 242 men who were still there when President Obama was sworn in, 38 have been released thanks in part to prevailing in their habeas petitions in the federal courts. Another, 100 and some odd, 95, have been transferred. But for those who remain, it's worth stressing that there are very different groups of detainees. So first, there are detainees who have been cleared for transfer or release, but just haven't been. As of Friday, that number is 57 of the 122 who are still there. You may ask, what's the problem, right? Why, if they've been cleared for release, are they still there? Well, 49 of the 57 are Yemeni. And for various reasons, the U.S. government has stopped sending detainees back to Yemen. 32 detainees have been slated for trial by military commission. 33 detainees fall into the category of the government says, we don't want to release them, but we can't try them. They're too dangerous, but we don't have enough evidence. And that's the hardest category. So with regard to those who have been transferred, who have been cleared for transfer release, there are two problems, right? First, diplomatic difficulties. We haven't been able to find countries to take them, if not Yemen. Second, Congress has made it impossible for them to be transferred to within the United States. So starting in 2011, Congress started enacting restrictions, barring the president from transferring the detainees without jumping through 37 hoops, and barring any transfer into the United States. So that's the problem for the transfer release category. With regard to the guys who have been slated for trial by military commission, those proceedings are mired in a complex mess of jurisdictional, substantive, and procedural objections. Objections that, it should be noted, would have been quickly dispatched by the civilian courts. Take the 9/11 trial, for example. In the 9/11 trial, the defendants asked to have the entire indictment read in open court. Right? This is 2,996 counts of murder. That took a little while. Right? In an ordinary civilian court, the judge would have said, you've got to be kidding, sit down and shut up. In the military commission, we have to look like we're fair. So yes, we'll read it in both English and Arabic. That will, be really quick. Come back in a month. Okay. So that's been part of the problem. In one case, right, the question is whether the military commissions are allowed to try domestic war crimes, right, things that are not recognized as international offenses. In another case, the question is whether they can try war crimes that were committed before 9/11. So was the bombing of the USS Cole in 2000 a war crime? Well, were we at war, right, with al-Qaeda in 2000? It's a harder question than you might think. And the 9/11 trial, there are lots of fights about access to classified evidence and so on. So those have all sort of bogged down into a mire. But the elephant in the room I want to suggest is the 33 detainees who the government believes are too dangerous to release but can't try. What do you do with them? Right? President Obama has, at the very least, emphasized that this is a legacy problem which just about these 33 guys, and so we should come up with a one-off solution. And if folks are curious, I can sketch out what that might look like in the Q&A. You're not going to like it. But that's sort of that's the legacy problem of Guantanamo. All right, so second, what do we do with new terrorism suspects arrested overseas? Well, in a May 2009 speech at the National Archives, President Obama articulated an absolute preference for using civilian law enforcement in all possible cases, no matter where someone is arrested or captured. Thus, in the last 6 years, there have actually been several dozen prosecutions of terrorism suspects captured abroad, in almost every case based upon these newly extraterritorial criminal terrorism laws. But there have also been a handful of high-profile cases where the government has sought to benefit from both paradigms, where the suspects have been subject to a short period of military detention and presumably interrogation before magically being transferred to a civilian criminal prosecution in New York. So one case in point is a guy named Ahmed Warsame, W-A-R-S-A-M-E. He's a Somali pirate who's affiliated with al-Qaeda, who was captured in the Gulf of Aden and spent 60 days on a Navy ship, presumably being interrogated. Lawfully interrogated, but still interrogated. And then magically he shows up in Brooklyn. to stand trial for criminal terrorism charges. Another example, Abu Anas al-Libi, who was captured in Libya, spent 9 days on a Navy ship. You may ask why only 9 days. Apparently he had a medical condition that couldn't be treated on the Navy ship, so they brought him to New York for medical treatment. Along with the prosecution of a former Guantanamo detainee, Ahmed Ghailani, who was tried and convicted for his role in the 1998 embassy bombings, these cases raise serious questions about whether the government should be allowed to have its cake and eat it too, to use the military force paradigm to avoid criminal procedure rules relating to the length of pretrial detention, interrogation, Miranda warnings, and so on. Right? And then only transfer the detainee to civilian criminal prosecution when either their intelligence value has lapsed or when the government might face other consequences. And let me just illustrate this with one case in point. In the Ghailani case, if you followed those proceedings, Ghailani was tried by a jury, and he was acquitted on 282 of the 283 counts against him. Imagine being, you're like, I'm winning, I'm really winning. Oh, wait, there's only one left. And then you lose. Okay. That would suck. Or if you're the government, that would be great. Whatever. Here's the problem. The government never denied that if Ghailani had been acquitted on all 283 charges, that it might reserve the right to re-detain him. Right? That as he walks out of the court, they might re-arrest him and send him back to Guantanamo. So that's what I mean about sort of bouncing between the paradigms, right? Taking advantage of the strengths of each paradigm to avoid the weaknesses. What's the weakness from the government's perspective of the criminal paradigm? You might lose, right? And the guys might be acquitted. Now, so far, the courts have not been troubled by this potential. They haven't been troubled by these cases, but there have only been 3 of them. Right? So it hasn't looked like a real problem. It certainly hasn't looked like the government has been trying intentionally to manipulate these authorities in a way that would raise concerns. But especially going forward, I think this is one of the most important questions we can ask. Should the government be allowed to take advantage of both paradigms in a manner that reduces their legal and political constraints? All right, then the last category, and this is actually where I sort of largely dovetail with Charlie's talk, is terrorism suspects who can't be arrested. This last category is the hardest. As mentioned, there are parts of the world where we're simply not in a position to arrest or capture, or even have friendly governments arrest or capture terrorism suspects. In those contexts, as Charlie explained, the government has increasingly resorted to military force, whether through drone strikes or other standoff attacks, at least for those suspects who pose a sufficiently immediate and imminent threat to our national security. Now, Charlie covered, I think, in pretty good detail the legal issues surrounding drone strikes in some depth and scared the crap out of me. And so I don't want to really rehash this presentation. I have this vision in my head now of little bumblebee drones flying around and flying into my brain, and it's like Inner Space. You guys remember the movie Inner Space? Okay. He's like, yes, now I do remember it. Thanks. But I do want to make 2 quick points that I hope are fairly obvious, even if they're often unstated. All right. So first, increasingly, drone strikes and standoff attacks is the only real military force that the U.S. is using anywhere other than Iraq. Okay, especially with the drawdown in Afghanistan, we really have largely retreated from the broad military force paradigm that characterized the first decade of our response to 9/11. And second, for all of the attention we pay to drone strikes, I don't think we're paying nearly enough attention to the flip side of that coin, to the number of cases of foreign arrests or captures where the suspect ends up in U.S. civilian courts, which is, in my view, mostly a salutary development. I don't deny the importance, utility, or legality of military force in cases in which it's necessary, but I also think that there are any number of reasons why, if our goal is prevention, incapacitation through criminal means should be preferable to other more permanent and less fixable approaches. So what keeps me up at night, besides, are the Mets really going to stay in first place all season, is the prospect of a future president, right? Be it Hillary Clinton, Rand Paul, or anyone or anywhere in between, taking advantage of the flexibility that could come from cross-roughing between these 2 paradigms in a way that redounds to the detriment of the constitutional protections to which we're all entitled. And as homegrown terrorism becomes an increasing threat in the coming years and decades, I fear that we're increasingly going to move in this direction, away from military force as a first instinct, not kill or capture, as the Michael Clayton book suggested are our choices these days, but rather capture, interrogate, and then eventually try. Thank you very much.
Thank you very much. We're open for questions. Steve Part.
Yes, thank you. I was wondering if we've passed this domestic law that applies internationally, what does that do to the theory of extradition?
So it works in two directions. So there are Let's take a hypothetical future case where there's a terrorism suspect who's in a foreign country. There are three possible routes by which we might acquire this person. The first is we might pursue extradition. We might ask the foreign government to arrest this person and then commence formal proceedings to have that person transferred legally from that foreign country to the United States. That is the most conventional approach. That's the one that has the most law surrounding it, et cetera. That is not the route we followed in most of these cases, partly because oftentimes our intelligence is better than theirs. In the second route, and the one we've done in other contexts, is with the foreign government's permission. Our own law enforcement personnel, and in some cases our military personnel, have gone onto the territory of said foreign country and have effectuated the capture or arrest themselves and have brought the guy back directly. So without ever going through the courts or the legal system of that country. As long as the foreign government consents, there is no international law objection to that kind of transfer. There may be an objection under that country's domestic law, but that objection cannot be raised in the U.S. courts. So that's sort of a sticky wicket. The third and the most controversial is cases in which the U.S. goes and captures or arrests someone on foreign soil without that country's consent. That is almost certainly illegal under international law, but there is a very controversial memorandum from the Office of Legal Counsel from 1989 that suggests that it does not violate U.S. law for the FBI to conduct an arrest that is in violation of international law. Even if, whether or not that, think about that for a second, that's a good one. That memo is very controversial. Whether or not it's true, there's a practical problem that's going to make this seem much less important. The defendant in this case can never object that the arrest was unlawful. All right, there's a doctrine in U.S. law called the Kerr-Frisbee doctrine, named after the two cases from 30,000 years ago when it was articulated, that basically says if there's an international law violation in an extradition or arrest, it is up to the governments to work it out. Right? The defendant cannot object to prosecution on the same ground. Do you guys remember the first of the new Batman movies? Right, the Christian Bale movie? Remember the guy whose Batman goes over to Hong Kong to arrest? You guys, maybe, right? Right. So he shows up in New York, right, on the steps of the courthouse. He can't object to that. I mean, he could sue Batman for damages, but that's not going to work very well. So the extradition problem only arises in cases where the U.S. has the host government do the arresting themselves. And presumably we only ask for that in cases where we feel pretty good about the extradition treaty. I hope that's a responsive answer.
I guess my question is that that third objective sounds an awful lot like kidnapping.
Yes, it does. I won't dispute that. I think the question then becomes, what are the remedies for kidnapping? And I think you may be surprised to learn that the remedies, although they exist, do not flow to the kidnappee. Right, that is to say, the person who is kidnapped cannot sue the United States for damages. His government can object through international legal processes such as they are. That's not to commend this. I mean, I think the U.S. tries to avoid this wherever possible. But if you guys remember from Charlie's talk, Charlie talked about the problem of non-acknowledgement, that a lot of these strikes are going on where we can't really concede why they're happening. In cases where we're picking up suspects overseas, it's entirely possible that we actually do have the host government's consent. They just don't want us to publicize that consent. So part of the trickiness in this whole conversation is what may look like an international law violation or kidnapping may in fact be a perfectly legal, non-extradition rendition that's just secret. And that goes to a whole different topic, which is the dangers of secret law in this area. But I think that's how the U.S. approaches it.
Steve, I'd like to ask a question of you. You mentioned the bombing of the USS Cole in 2000, and then you asked, were we at war in 2000? So that makes me ask, given that there were fatwas issued by Al-Qaeda and associated institutions in 1996 and 1998, sure, in effect declaring war on the United States, were we at war? Is there a legal dimension to this?
So it's a great question. I think let me take it as both a domestic law question and an international law question, because I think you actually get slightly different answers. The international law question is, was there an armed conflict? Right, and that is, to measure that, we apply something called the Tadic test. This is a case law from the Yugoslavian War Crimes Tribunal. And the Tadic test looks at the intensity of the fighting, the duration of the fighting, the scope of the fighting. And under the Tadic test, a series of scattered terrorist attacks over a period of time, combined with some propaganda, does not an armed conflict make. Right? So I actually think it's pretty straightforward that the United States was not involved in an armed conflict with Al-Qaeda until at least 9/11. Well, I shouldn't say at least, until 9/11. 9/11, yes. The domestic law question is trickier. The courts have held that Congress does not have to say it's a war for it to be a war. And so I think the question is, did the executive branch, did DOD, right, did the military, did anyone who mattered treat the conflict, such as it was, as a war at the time it happened? And despite what Al-Qaeda did, I don't think there's a lot of evidence that the U.S. response to the Cole bombing was a military response, as opposed to a law enforcement response. So I actually think it's a real... The U.S. government, of course, disagrees with me. The U.S. government has filed detailed briefing in the Cole case in the military commission, explaining why they think we were at war since at least the embassy bombings in 1998. But I think it's a long shot. I mean, I really think it's a hard argument.
Paul Dickler?
So if I combine what you said and what General Dunlap said, let's take a case where someone's accused of treason, say an Edward Snowden, and say the NSA has gone forward and said they've now determined he has enough information that could put lives in jeopardy if they're released or whatever. And he's in a country where a drone strike is not conceivable.
Yeah, I don't think we're going to use a drone in Moscow.
So the question is, he could legally be killed by an agent of the United States. He couldn't be legally extradited against, without another treaty with Russia. In other words, it does seem that only the most drastic measures would be legal. Is that correct?
At the risk of disputing the premise of the question.
Then change the person.
So let me do that. So let me explain why I disagree with Snowden and why I'm happy to answer the question about. So Snowden's not a combatant, right? I mean, whatever we think of Snowden, good guy, bad guy, best friend, worst enemy, right? He's not part of the armed conflict between the United States and Al-Qaeda, right? He may be a bad dude. He may violate, right? So let's start there. Now let's take someone who is, right? Now let's take
I'm not sure I agree with that premise. Because if he's working for the NSA, isn't he a part of the organization that's involved with the defense and the war?
I mean, so I don't think he is but then you're saying, can we kill one of our own combatants, right? So then your position is he's a combatant because he's on our side.
That's what General Dunlap was saying, that's legal.
Yeah, I'm not sure I agree with Charlie on that one, although he's not here, so that's easy for me to say. Let me flesh this out. I mean, I do think, first of all, I still think he's not a combatant, even though he is a member of even though he was working for the NSA and the NSA is involved in supporting the military mission. I don't think being a civilian employee of the military does not make you a combatant. Okay. There's a lot more to it. Let's assume someone who actually is a combatant. And who is in a foreign country that has a perfectly functioning government that we don't get along with, because that's the hard case. And I think in that instance, there are no legal remedies other than trying to convince the foreign country to help us out. Right? And I think that's why Snowden is in Moscow. I think that's why Julian Assange is chilling in the Ecuadorian embassy in London. Right? If they were in countries with more unstable security situations, they would be vulnerable to the kind of operations I've described. I don't think the U.S. has any legal authority or political interest in conducting any of these operations in England, in Russia, in any of those countries. Right. The question then becomes what kind of diplomatic and political pressure can be brought to bear on these governments to try to help us out. And I think the answer is Russia is probably singularly unique in being the one country with which that won't help at all. Right? That is to say, I don't think it is an accident that Edward Snowden ended up in Russia, because I think that is the only country in the world where we would really feel stuck. And I do not believe we would have legal authority to do anything without the consent of the Russian government.
Is that Javier Igueta? Yeah.
I was struck that you said that, I believe it's the Hamdan decision that basically took, as you put it, the argument that about whether terrorism is effective off the table.
Torture.
Sorry?
Whether torture is effective.
Torture. Because quite clearly that debate is not off the table in this country. And in fact, I think that the recent surveys show that support for torture, even after it was revealed by the torture report, is rising among virtually all groups.
So, I think that's a really good point. I think that we have to draw a very bright distinction between the moral justifications for torture, such as they are, and the legal justifications for torture. And to be clear, I think there are zero legal justifications for torture. Right? That's not to say that there might not be moral justifications. If you actually accept that there could be a ticking bomb hypothetical, which, by the way, has never happened in the history of the world, but if you accept that it could happen, maybe there would be a case. This is how I like to teach it when I teach it in con law. So you're driving your sick loved one to the hospital, right? You come upon a red light. Okay? Do you go through the red light if, you're at a point where seconds matter? And the answer is of course. Right? I mean, you look both ways, you make sure you're not going to die, but you go through the red light. When you get pulled over for running on the red light, do you say, oh, well, officer, my violation of the law was morally necessary, therefore you shouldn't ticket, therefore I didn't break the law? No, you say, give me the damn ticket, I'm late. Right? I mean, the point is there are some times when there are things that are more important than the law. And so I think what Hamdan drives home is that legally torture is never permissible by U.S. officials in the United States as applied to U.S. detainees, period. It's prohibited by Common Article 3. It's prohibited by the Torture Convention. It's prohibited by federal statutes. Whether torture might ever be morally necessary is, I think, a much harder question, and one that, since I'm a lawyer, I can duck. But I think it's worth. And so when pollsters ask Americans, do you think torture is ever okay? Right? That question is horribly ambiguous about whether you're asking whether it's legal or whether it's morally necessary. Right? I want polls that ask those two questions, because I think we should be wise enough to be able to distinguish that, we've all broken the law sometime in our life, and we probably didn't think that we could get away with it because it was necessary. We probably just did it because it was important, convenient, or something else.
Gary Morris.
Very good presentation, and sadly you were the last, but...
Why sad? We get to party afterwards.
Yeah, that's true. My question is this. When we look at the situation in the world as it is, and we look especially in the United States, where do we draw the line between the rights of individuals and the protection of the common good? Because I think, especially with the USA Patriot Act and other legislation that has come down the pike, that line has become extremely blurred, and it's a concern.
I mean, I think that's an impossible question to answer. I do think that we have come to a point as a polity where we assume that individual rights can and should take a backseat to what we perceive to be in the common good. I mean, I think if you forget the conversation about like drone strikes in Guantanamo, look at surveillance, right? I mean, the extent to which there has not been a backlash against the surveillance programs that were disclosed by Edward Snowden, I think is better proof of the current sort of mindset, right, of the American public than anything else that I could come up with. And I think what that all reflects is the sort of I've got nothing to hide mentality, right? Why should I don't have drugs in my purse. I don't care if they search it before I go on the subway, right, or something like that. And I think that that's a mentality that doesn't just come from the government, it's a mentality that comes from all of us. I think it's generational to a degree. I suspect you guys see it with your students. I know I do, right? And I think, it's, without taking a position on whether it's right or not, I think it's worth asking, how has it come to be that so many of us and so many of our students are no longer in a position where they can actually empathize with the rights of others? Right, where they're at a point where if it doesn't affect them personally. I was speaking on a panel about a month or two ago, and an undergrad student in the audience asked me if I could specifically identify the rights of hers that have been weakened since 9/11. Right, she said, I want a list, right? Give me a list of all of the rights of mine that are lesser today than they were on 9/11. So first I said that is so not the right question, right, and berated her for about 5 minutes about why it wasn't the right question. And then I gave her a list, right? And I said, and oh, by the way, here are all the rights that are not as profound as they were. Now, I said, you may not care about that, right? You may not be planning to spend time in jail, where the fact that you have less of a right to a hearing and less of a right to, good conditions of confinement, right? I mean, you may not anticipate that in your life you're going to need these things, but that doesn't matter, right? So I think it's a mindset problem that goes far beyond terrorism and far beyond, how we deal with the Islamic State and these kinds of emergent threats, and goes to the core of our ability to empathize with those around us.
Can I ask one more thing? Okay. So do you believe then that as a country we've reached a point where we're willing to accept giving up more rights in order to protect ourselves?
Yes, but indirectly, right? That is to say, I don't think if you frame the question that way, people would say yes. I think we've reached a point where we are perfectly willing to give up other people's rights, right, for what we perceive as a little more safety. And I think the problem is that way too often, folks don't realize that in giving up other people's rights, they're giving up their own.
Final question from Mark Ladd.
On the dichotomy you mentioned between the military and the criminal setup there, my question is, when you look at the cases the court dealt with dealing with the habeas rights and things to that nature, is the debate over the act itself, since it hasn't been a 9/11, but it goes to your material support, that now my action isn't necessarily terrorist, but it's the support of terrorism that pulls it from a military issue into the civilian courts?
Can I ask you to clarify? I mean, are you asking about the habeas cases or the criminal cases?
Well, I guess my confusion is I'm not really sure on
okay, fair. So let me walk through this, and then if there's still a question, please elaborate. So the criminal cases, right, the civilian criminal prosecutions are ordinary civilian criminal prosecutions, judge, prosecutor, defense lawyer, jury. And the question in those cases, if it's a material support case, is did Steve Vladeck, the defendant, know that when he provided this thing to that group, that he was providing material support to a designated terrorist organization? And that's actually pretty easy to prove in most of these cases. That's how we're going after most of the guys we're getting these days, right? I think the statistic is something like there have been over 150 material support specific prosecutions since 9/11, and that only went up after 2004, right, when we started applying it overseas. The habeas cases are asking a different question. So if I was a Guantanamo detainee, I'd file a habeas petition, and the petition would say, "Dear Judge, I believe the government does not have the authority to hold me as an enemy combatant." We don't call them that anymore, but it's something like that. Which is basically saying, I am not a part of al-Qaeda. Right? So the question the courts have deployed in the habeas cases is, can the government prove membership? Right? So like if it was World War II, can the government prove that you were in the German army? Well, you were captured wearing a German uniform, right, with German that was usually pretty easy. It's harder today because, as we learned yesterday, right, members of al-Qaeda don't wear the normal insignia, don't follow the normal rules. So the government usually has to provide circumstantial evidence to prove that Steve Vladeck actually is a member of al-Qaeda. That evidence tends to look something like this. We captured him here. We have intelligence that he was staying at a guest house known to be frequented by al-Qaeda folks for these 3 nights. We have intercepts of his communications with these known al-Qaeda leaders. And the burden of proof, and this is probably the most important point, the burden of proof is lower. So whereas in a criminal prosecution, government has to prove beyond a reasonable doubt that I knowingly gave material support to al-Qaeda, in a habeas case, the government has to show by a preponderance of the evidence, which is fancy legal speak for 51%, or 50.1%. So basically, the government has to show it's more likely than not, based on the evidence, that you are part of al-Qaeda. Government does not have to show that you are a threat. Right? The government does not have to show that you ever fired a gun. Government doesn't have to show anything other than membership. And if they can show that, that's enough to hold you at Guantanamo. Now, with a burden that low, it's worth stressing that of the 61 detainee cases adjudicated on the merits, the government still lost 38 of them. Right? For the guys who were still at Guantanamo after 6 or 7 years, the government's success rate on that low showing with circumstantial evidence was still well under 50%. So is that responsive to what you're asking?
Yes, well, thank you.
Yeah, thank you.
Okay,
I think we're done. Woohoo!